Trial of former tennis champion Bob Hewitt resumes in the High Court, sitting in Palm Ridge today. The 75-year-old stands accused of 2 counts of rape and 1 of sexual assault dating back to the 1980s and 90s. Last week, the court heard testimony from 3 of Hewitt's alleged victims as well as their families. Now, joining us for a discussion on the merits of this case is legal expert Elton Hart, who's from the University of Johannesburg's Law Clinic. Good morning, Elton. Thanks for joining us.
Good morning, Eben, and thanks for having me.
This is an interesting case. We've seen a couple of these cases now around the world with accusations coming out many years afterwards. Let's start with this particular case. What's your view on it within the legal framework?
Eben, from a legal perspective, it's pretty normal for victims of crimes of sexual assault or rape, as it was called in the old days, that people would come out of many years after the incident that has happened, especially when you have like victims that were minors at the time of the incident. So it's not a new thing, it's just it goes unreported in our legal system that we don't hear about it very often, but these things happen on a daily basis, and it's one of the things that we as lawyers have to deal with.
How do you test this kind of case, though, with so much time that's elapsed and so much water under the bridge? How do you test it? What does the law say?
Yeah, but very recently, in 2009, the Constitutional Court actually made a ruling in the Els case, which stems from the Northern Cape, actually, where they looked at certain factors. They look at the length of the delay, the nature of the offense, the trial prejudice to the accused. But in that case, the judges also in the Constitutional Court also looked at the public interest in that when they look at trial prejudice. So it's not just one tier test. There's 4 factors that they have to look at to see if it's in the interest of justice to stay prosecution. Because an accused can just not come and say that the length of the delay, it's maybe the pre-trial delay, but the delay in his trial was not that long, because the victims came out and the trial immediately resumed. So the delay in the trial should be, if you look at the Constitution, Section 35, 3D, then something different is applicable here. Maybe the witnesses, then the judges would look at the credibility of the witnesses and those kind of things if they make a value finding on the evidence that is placed in front of court. So it's not really the delay, it's maybe the pre-trial delay here.
In this particular case now, we see the letters, of course, that were written, and then also the witness testimony will be very important. How do you view this particular case with the witnesses and what you've seen come out so far?
The thing is, like with the witnesses, one should also not forget the fact that these were single events, if one can call it like that. It's not that the one victim knew of the other victim. They were like victims in different scenarios. So the court needs to apply the cautionary rule. You're looking at the evidence in compartments, one can say. But there's also something in the law of evidence which states similar fact evidence, where the court can look. But then the accused attorneys can argue that it's not in the interest of justice and fair trial because these are unrelated incidences where you can bring similar fact. But if the prosecution is clever enough, they can try and slip it through that gate to actually show that this accused has a pattern or a habit of doing things.
And let's talk about the credibility of a witness. How credible is your witness testimony, say, 3 years later?
It can still be credible. It depends on how the witness, the judge, when the judge looks at certain things, the judge look at how the witness is behaving in the witness box, the demeanor, and also recalling of the events. They won't expect the witness to actually remember the detail in precise, but certain events, if it just corroborates and it makes sense, it's a plausible witness statement that is given, then the judge can't find that it's an uncredible witness. We need to look at the accused answer to these events. And there the court will look at finding who's the more credible witness in the instance.
In the one witness's case here, Ellen Sheehan, she had no relationship with her parents, who to this day refused to believe her about the rape allegations. How is this kind of thing viewed within the context of this case?
The thing is, like, one need to, as I said earlier, we need to look at the witnesses individually because it's individual cases. And if the parents don't want to believe the witness, sometimes it's very difficult for kids, and it's exactly like if you look at the third victim's case where she was too afraid to tell her parents about this because she feared rejection. And that's normally when minor victims don't tell, and that's when the secrecy and denial comes in, where they blame themselves for what happened. So one should also be very cautious of this. And I also heard in the news, and I didn't dig too deep in it, where parents came and said that she's a pathological liar.
Yeah.
And one needs to treat that evidence with caution, and the judges needs to most probably examine this and see if this is really true, what the parents has put before court, and if it's not true, then they should deal with it in a specific way.
Conclusion, what about precedent? We've seen these kind of cases pop up around the world. In Britain, they had a case with celebrities, Jimmy Savile and the like, who were drawn into sort of child sex rings and so forth. We've had the high-profile Bill Cosby case. As the person who is accused, it really ruins your reputation. Whether you are innocent or found guilty, the damage lasts for the rest of your life. What kind of recourse do you then, as the victim, have in a case like this?
Obviously, civilly, you can actually claim damages for your reputation, but I mean, no amount of money can actually restore your reputation. Once it's out there, people always have this perception in their brains, maybe it's subjectively that you this type of person. So even if you can claim millions and millions of rands from the complainants, it will never fully restore you. And this can be seen from the previous matters that we dealt with, like Oscar Pistorius. It was also similar. Damage has been done to the reputation of the person. So it's not, money cannot really, it's sometimes like a lesser value, but money can't restore the reputation, it's gone. Luckily for some of these guys, they're already in the late stages of their careers, so there's nothing really that they can monetarily still lose. It's only their reputation, their good name that they had for 40, 50 years.
And your good name has no value?
It does have value, but I mean in the entertainment industry where these guys most probably found themselves, I mean 75-year-old, 80-year-old, he's not going to play tennis anymore. So.
Yeah, that's where one questions the fairness of this kind of scenario, because whether you find guilty or innocent, the reputational damage is irreplaceable. You can't, it's irrevocable, really. But Elton, thank you for coming in today to talk to us about this. Very few people wanted to touch the merits of this case, really. So thank you very much for coming in and putting it into a legal framework for us. That's Elton Hart, who's a law expert from the University of Johannesburg's Law Clinic. Thanks.
Thank you, Evan.
Quick look at your tweets. What are you saying? What are you saying about this matter? Is it this matter? Well, let's have a look at what's on Twitter.